Announce the case.
We're on the record in case D-15-521-527, Turner versus Rodriguez.
Thank you. Counsel appearances and your bar numbers, starting with the plaintiff first, and if you're retained or unbundled.
Good afternoon, Your Honor. Jack Freeman. I've been retained. Bar number 10584 on behalf of Michael Turner, who is also present.
Good afternoon, Your Honor. Kenneth Robbins, bar number 13572. I'm unbundled for Ingrid Rodriguez, who is present.
Okay, and I see the mom and the dad there. This case is reopened. Whose motion is it?
It was Mom's motion.
You may proceed first, Mr. Robbins.
Thank you. So, look, I mean, I assume you've read our motion. Our motion pretty much speaks for itself. The allegations here are that dad has been sexually inappropriate with the child. Upon mom getting this information from dad since, I believe it's early July, the child has been solely with mom. She has made that decision to not continue with the visitations until we were able to come back to court and have this heard. But what is happening is extremely concerning to mom. The child has been coming home to mom and exhibiting signs that a normal 5-year-old child would not be doing. These include extreme acts of sexual touching of herself, and then reporting to mom that she's learning this from dad, that dad has been sticking his fingers in the child's vagina, licking the child's vagina, and whatever else, things of that nature. Mom has reported this to CPS and to a detective. Unfortunately, they are not taking this allegation very seriously. And the reason being is that this is not the first time that mom has made that allegation. So she brought this forward previously, I believe, around the beginning of this year, and the child was interviewed by a detective, a forensic interview, and the child didn't disclose at that time to the interviewer that she had been being touched by dad. Since that interview has occurred, the child now has disclosed it, and disclosed it to a police officer during one of the exchanges, and that was on July 17th of this year. The police officer, I do have the police report, I just received that today. The police report does indicate that the child did say to the police officer that the dad was touching the child inappropriately, and that the police officer was making a report of that and sending that to CPS as well as the detective. I spoke to the detective today, and the detective told me that because the allegation is in close time proximity to the first allegation and to the interview, that she was not going to do anything about it, that she wasn't going to reopen the case, and that basically she was going to ignore this allegation. Now, the videos that mom has taken videos of the child's behavior upon returning from dad, and she brought that to a detective, I believe on Friday. That detective was forwarding those videos over to Detective Heredia, who was previously on this case, and when I spoke to Detective Heredia, she told me that she's viewed 2 of the videos. However, there are more, and that because Ingrid is speaking in the video, I believe to the child in Spanish, and Detective Heredia is not fluent in Spanish, that she can't take any action on the video, that she hasn't seen the other 3 videos because for whatever reason they wouldn't upload on her computer, but the other detective has seen the videos. I spoke to that detective yesterday. That detective told me that these videos are extremely disturbing and not in any way regular for a child of this age to be acting. And that's where the majority of mom's concern lies, is the way that the child is acting each time that she comes home from dad, and then stating to mom, to police, and to a therapist who has also made a report to CPS that she's learning this from dad and that dad is doing these things. There's also concerns regarding exchanges in general. There's been a previous order that dad's not to have a gun during exchanges. Mom recently showed me a video of one of the exchanges where dad has a gun on his hip, open carrying to the exchange. Some of the exchanges have occurred through dad's mother, paternal grandma, and during these exchanges, paternal grandma is extremely combative with Ingrid, with mom, accusing mom of intentionally harming the child by medicating the child and giving the child laxative. The child has a problem with going to the bathroom and has been prescribed this laxative by the doctor. Unfortunately, dad refuses to give the child the laxative, and the doctor told mom to give the child additional dosage before going over to dad if dad was going to refuse to give the child the medication. So that's what she's been doing. Now dad's trying to say, and dad's mom is trying to say, that mom is intentionally trying to ruin the child's time with dad by making it so the child is having diarrhea during his timeshare, which is completely inaccurate. If dad would just give the child the medication when he would have his visitations, and that wouldn't be an issue. The child's not having nearly the problems that she's having when she's with dad because of that medication. That's basically where we're at, Your Honor. So I also wanted to mention that dad filed a police report over 4th of July weekend stating that mom had kidnapped the child when in fact it was actually mom's time to have the child because it was the 4th of July weekend and mom's turn to have the child. So dad then filed a police report against mom claiming kidnapping, which is inappropriate. I also would like to request that either the exhibits filed by dad be stricken or for this case to be sealed due to some of the exhibits that were filed showing graphic images of mom, which really have no substance or relevance to this case other than to try to paint mom in a disfavorable light. Nude photos of mom, which I assume dad provided to his attorney in an unedited form, and then dad's attorney was the one that edited it before filing it with the court, which would be inappropriate for dad to then share these intimate photos with any third parties. So either strike that exhibit or to seal this case, which, given the nature of these allegations, I think sealing this case would probably be appropriate anyways. Thank you.
Your Honor.
Okay, Mr. Freeman?
Sure. The allegations in this case are horrendous, and they're 100% false. The child is in danger, and the danger is mom. This court has seen this case before. This case was in front of the court. Mom made allegations in the last go-around about a year and a half ago that dad committed domestic violence. As a precaution, dad was placed on suspended or supervised visitation. Dad actually went to a criminal case because of mom's accusations. Now, the police officer on the scene, when mom flagged them down the following day, documented very well that what mom was saying was not supported by any evidence, that her statements were contradictory. The police officer did not arrest dad. 3 months later, a detective filed that police report and somehow got an arrest warrant. We were before the court, and I told the court last time that arrest warrant was bogus, and it should never have been granted. Dad went through the criminal case, was acquitted, found not guilty, and more importantly, and we've submitted it to the court, mom was found to be not credible. She was found to have conflicting stories. She was found to have not produced any evidence of injury. She stated that her jaw had been broken, that her back had been broken, that she had been choked. Zero evidence. She showed the police officer on scene the following day again when she was walking to a domestic violence class that she had to take because she committed domestic violence against dad. She was walking to her class. She flagged down a police officer the following day, said, "My boyfriend assaulted me last night, choked me." She showed him a video. The police officer in his report said, "The video doesn't show anything of the kind." That video because we had an evidentiary hearing set, I think this last December or something, we ended up settling because mom wanted to relocate to Florida. That video was never produced, and mom in her deposition says she lost the phone or she doesn't have the phone anymore. She couldn't produce the video. She couldn't produce it in the criminal court either. I bring that up here because that's an indication of how mom has behaved over the years, making allegations. That one was domestic violence. She also accused dad of pointing a gun at the child. That was investigated by CPS and closed, unsubstantiated. She's made previous sexual assault allegations where dad has allegedly sexually assaulted the child. She's made those to CPS. Those have been closed, unsubstantiated. I talked to the detective before counsel did, and the detective told me, case is closed, I have no concerns about dad. Now there's a video that mom has, never produced to us, not produced to anyone, that allegedly shows, the child acting inappropriately. That video wasn't produced to the detectives until Friday. Mom has withheld this child since June 30th. And they want to complain about a police report about July 4th and mom kidnapping. Mom has withheld the child since June 30th. Whether July 4th was dad's time or mom's time is irrelevant. Dad hasn't received any time since June 30th. Mom withheld the child in the past. When she withheld the child in the past, the reasoning was that dad had left the state without her permission with the child. So we went through this last time, and the court reiterated, you have joint legal custody, no permission is necessary, but you do have to tell the other parent where you're going, provide the itinerary, that type of thing. In mom's emails and our talking parents, in June, March, February of this year, she's complaining and saying, I'm taking you back to court because you keep taking our child out of state. And dad keeps saying, I don't need your permission, and I've told you that where we went and where we were going. And mom says, no, you do need my permission. We're going back to court. Following that, she says, your mom's not allowed to pick up the child. We're going back to court. Neither of those things worked for her, so now she's made sexual abuse allegations. Unsubstantiated by CPS, closed out by the detective with nothing. Now, a few days before court, there's a video that's been produced to the detective, and the detective is allegedly very concerned. Also, there's allegedly a video of dad having a gun on his head. None of this has been produced. None of it was in any of the pleadings. It's last minute, hey, let's give it one more shot. Your Honor, with all due respect to the opposing party, she has lied for years. She has made allegations against dad for domestic violence, sexual abuse, gun use. All these things, none of them proven. She has been proven to be not credible in a court of law and to have lied about what allegedly happened. We are asking for sole legal custody of the child immediately, temporarily, and pending an evidentiary hearing. We're asking for a mental health exam for mom under Rule EDCR 5.305B because she needs to have some sort of mental health evaluation. I deposed her last year. It's on video, and I can produce some of that stuff for the court as well. She was contradictory and back and forth in her testimony. I think the court would see very clearly she's not a credible witness at all. She filed a motion to relocate. That was the evidentiary hearing. Her basis was family in Florida. It came out in her testimony. She had a friend in Florida. She has no family there. She didn't even know the friend's husband's name where she was allegedly relocating. Her case fell apart. During that time when she was accusing dad of domestic violence and pointing a gun at the child, she was sending dad those nude pictures and trying to lure him to her place. That is why they were produced through discovery prior to the last evidentiary hearing. That's why they're produced now, to show that she's absolutely not credible. She makes these horrendous allegations while she's trying to get dad to get back with her. And as far as the laxatives go, that was also produced last time and introduced last time. Mom overdoses this child on laxatives. She wouldn't allow dad to have any contact with the doctors previously. That was another issue that was had. She had put that only she was allowed for pickup on the prescription bottles last time. So she has this laxative and she overdoses the kid. The kid, we've got pictures. I could produce them, but they're just of diarrhea in underwear and things like that. So I don't know that the court needs to see them. But dad, every time he gets the child, explosive diarrhea for the first day or two until she gets back to regular and sends her back to mom. Then mom complains, oh, she's constipated again. I got to put her back on the laxative. So mom's conduct here, I think if the court got the CPS records and things like that, it might be insightful. Now, supposedly, there's a detective that's involved again. I can represent to the court. The detective told me there's no concerns with dad whatsoever and that it was closed. I am very concerned that mom has video of the child doing things to herself. And I'm concerned about that because I think it's probably because of mom. Mom has manufactured things and said things over the years that are horrendous, and she continues to do it. The child's in danger. We're asking the court to give dad the child, suspend mom's visitation, order the mental health exam. Other than that, we are also asking that mom file an amended 2019 tax return. The last court order states that dad will claim the child on his taxes until mom can verify she has full-time employment. Mom's never done that, and this was in December this order came out. And then almost immediately after, she files for the child on her taxes, even though she has no full-time job. So she doesn't care for court orders. Dad has missed, I think, at least 17 visits, maybe more now. And then she also violated that other order with the taxes, and we're asking for order to show cause to issue on all those.
I'm looking at your exhibits. One is a trial transcript of the criminal case. Is that correct? That exhibit 1 to your opposition? Are those your exhibits, Mr. Fleeman? Oh, he froze up. You gotta wait till he gets back. Are you there? Might have connectivity issues. Can you hear me? Okay, so I'm asking about your exhibits here. I'm going through them. Exhibit 1 is a trial transcript. Is that what it is?
You're muted. Mr. Fleeman, you're muted.
Thank you. Yes, it is, Your Honor.
Nothing in there was highlighted, so what in the
MST 0008, it's cited in our opposition.
Yeah.
It's page 29, beginning at line 9. Page 28.
Okay.
It's a little confusing because there's a 29 in the right-hand corner, but there's a 28 at the top of the page.
Okay. What do
Line
you...
9. Line 9 says, "All right, sir, at this time I do find you not guilty. I do not find the victim, Miss Ingrid Rodriguez, was credible. Her testimony was not corroborated by evidence. In fact, it was contradicted. She claims to have internal bruising to her neck and broken jaw. There was a stack of medical records over 300 pages that showed absolutely no evidence of any injury. There were also pictures taken that showed no injuries. I am concerned about the numerous times she called police on you when you had visitation with your daughter, which was also another issue last time. That's in common between the two of you. None of these allegations were substantiated, and in fact, the victim admitted to making up some of the stories. She also made contact with the police, specifically Officer Myrold, a day after the incident. At the time, there were multiple inconsistencies. There was a lack of evidence as to the injuries to the areas where complained that there would be an injury, specifically being the neck, chest, and back pain. The officer also did his due diligence in that he took photos, and none of the photos show any injuries of any type. In fact, the only injury was an old bruise on her bicep. It's telling to me when the officer that was supposedly there the day after the incident believes that he had no probable cause. Based on the totality of these circumstances, again, I find this victim to be incredible, and I do not believe that the state met its burden. And that was the same argument that I had made a few months earlier to this court when the criminal case was pending and the court put Dad on supervised. But the problem was that the officer who was there, somehow they got an arrest warrant from a detective 3 months later based on what the officer said of the day of, and then when it went to a criminal case, her story fell apart, as it had with the officers the day she reported it. So there was never any real evidence that anything had happened. But she dragged Dad through the court, through the mud, claiming all these things, and none of it was true. She even claimed she had a video. Never produced to the criminal court, never produced in our family law case, phone, gone. She couldn't show the video. And her attorney in the case last time said, we have a video that we'll produce. And it was never produced.
What's with the Exhibits 2? What's the relevance of Exhibit 2? The timing of these photos that...
Yes, Your Honor. These photos were... Right, our evidentiary hearing was set, I believe, for December of last year. These were sent in October of last year, which was a time when she made allegations in the case that Dad had held a gun to the child and that Dad had committed domestic violence against her and that he was dangerous. And these photos show she's sending pictures to him of her in the nude and trying to lure him over for either she wants to get back together with him or she wants to make another domestic violence allegation against Dad when he comes near her. So we produced these in discovery during the last case, And it wasn't that long after we produced them that she stipulated she wasn't moving, and it all went away. That was resolved in December, and then almost immediately after that, in February, she starts telling Dad he's violating orders, he's not going to see the kid anymore, to where that escalates to June 30th, where she withholds the kid again. So she didn't even go, she went basically 6 months without withholding the kid and making allegations. I would also note in that deposition that I had of her last year, towards the end of this case, the last case, she made the allegation there that recently the child had said Dad touched her. That allegation hadn't been made prior in the case. It was made kind of as a surprise allegation in the deposition. And when she was pressed on it, she said, well, I reported it to CPS. But she alleges that the child had said it only a couple weeks earlier, and she hadn't talked to CPS in 4 months. So when she was pressed on it, she said, well, I didn't call them because I knew they wouldn't do anything. I just knew they wouldn't do anything because they told me we're not going to change anything. You got to go back to court. That's her claim now, is that CPS doesn't want to do anything. It doesn't make any sense. It extends beyond reason, and it's the course of what she's done for years.
So Dad also mentioned this latest incident. He showed photos of something about Mom kissing his face the day before. Did I read that correctly in the opposition? And something like a Zoom video. I want to kind of understand the context of that, unless.
I'm not sure exactly what the court's referencing. It was an allegation that someone was kissed in a Zoom video.
Maybe Dad can explain, but I don't know if he wants to say anything. And I know there's no criminal case filed, but he knows the process. Let me go back to my notes and tell you what is written in my notes.
Okay.
Yeah. Well, maybe we got this off of Mom's. Maybe Mom. No, we got this off the CPS records. So I do want to tell both lawyers that we'll send the CPS records. My staff should have sent that to you PDF under a confidential gag order. The updates as of August 14, 2020. On June 9th, Detective Heredia contacted Intake to provide an update regarding her investigation on this family. At this time, interviews were conducted with all parties and the child. The child did not disclose sexual abuse. An interview was conducted with father who denied all allegations. The father also provided detectives with a video of the mother from May 26th, the day before the interview with Metro detectives, showing the mother kissing the father's face and mouth. It was also observed that she had done a Zoom video where she was topless and expressing her desire to have a relationship with the father and have their home back together. The father agreed to a, buccal swab. I don't know what that is, buccal swab. As the father is the primary caretaker, he wipes the child as part of his parental duties, which does not constitute sexual abuse. Detective Heredia expressed concerns as to the mother making these allegations several times in the past. The case is being closed due to insufficient evidence. And on August 13, 2020, who is this psychologist, Danielle Bello, of the Care for the Kids, called to report that the mother is stating that the father has molested her child. She stated she has two videos, a video of two occasions where Mariella is taking off her clothing and touching her vagina. She stated that detectives were involved but never saw the videos. There's more here. Let's see. I just want to give you the short version. Let me just scroll down. Source is a mandated reporter. I thought they would call because while it sounds like matter was investigated, they are not sure. This is all of the conclusions for the NIA, completed on 1/25/2020 and approved. I think they meant June 25th, 2020. NIA conclusion determined there are no impending dangers. Family has sufficient resources, support to ensure the safety, well-being of Mariella and to provide for her basic needs. The mother was given the department resource guide, recommended to take her daughter to therapy. And Mariella is currently attending therapy twice a month. Case is unsubstantiated and recommended for closure based on the findings. Did mother inform the father she was going to take the child to therapy? Here's the thing.
No.
You've got a mother going to Metro and CPS. When Metro or CPS tells you first of all, she did not confront the father first about it. She went straight to the agencies. When Metro, if you're a concerned parent, and if Metro tells you the case is closed out, I suppose one argument is, wouldn't that parent be relieved that they didn't find anything about the other parent? Most concerned parents normally would confront the other parent about it, but I know this has always been a high conflict case. And when a concerned parent, the detectives tell you, no, your child's not being abused, I would think that parent would be relieved. So it appears in this case, maybe mom's taking the position she's not relieved. So dad is questioning her motivations, that she's just using the child as a pawn for whatever their past relationship issues were. But that was a long discussion. We started out with dad showing the Metro video.
Yeah, I can give a little bit more insight on that.
To say mom wasn't credible, but this is a matter of common sense. When you police tell you, look, your daughter's not being abused, I would think a logical parent would say, thank God, I'm relieved, but instead, she takes more action. She creates, more videos, submits more evidence after finding out that the daughter's not being abused. So she just won't accept any agency. You have 2 agencies telling you, Mom, your daughter is not abused. I don't know, you're going to stop. And that's why I think first of all, let's start with the exhibits. Do you oppose sealing Exhibit 2? I mean, the whole case wants to be sealed. Do you oppose sealing the case?
We do not oppose that.
All right, so, let me type that in there to my court clerk. The court case is sealed. Everything is sealed except the complaint, the answer, any judgments or orders. So everything else is sealed. That means all the exhibits, all the pleadings, etc. Only the parties and their counsel will have access to it. The second point is, that is a finding. CPS closed out the most recent case, this recent case. Okay. And the only thing that's hanging in the balance here is, has Metro taken any additional action after mom produced additional videos? And there should be a discovery exchange of all the videos in her possession. So mom is to produce the videos as part of this. If she has it electronically, put it up in a Dropbox, Mr. Robbins, or a flash drive or something. To produce the videos to Mr. Fleeman. Every video she has in her possession. We need to follow up with Metro. Does Dad live with the grandparents per the last court orders? I will continue with that. They are typically, he's not under any supervision requirement. Did we lift that eventually?
That's gone. We stipulated to everything after that. Dad actually has more time under the order than mom. We just kept calling it primary physical custody because that's what was required.
Okay. Let me err on the side of caution. We need one more agency. There's a follow-up with that, and I'll try to expedite that. I want Mr. Robbins to subpoena Detective Heredia for the next court hearing. They will appear on blue jeans, okay? And then we'll hear it from the horse's mouth. If they plan on the case, I want to see if the case is closed. If the CPS case is closed, the detective's case is closed, there is no basis to restrict Dad's contact. But let me err on the side of caution. Dad, the paternal grandparents, your parents, will be your supervisors pending the, the next court hearing with our Detective Heredia. So I'll make a note of that. So you're responsible for that, Mr. Robbins. I don't want to waste my court date. Attorney Robbins to subpoena Detective Heredia. Okay, let me put that in the everyday chat box. I was in the wrong chat box. Hold on. Attorney Robbins to subpoena Detective Heredia for next court date. Well, with detective schedules, how easy are they to get hold of? 2 weeks, 3 weeks, 4 weeks, just to make sure they're going to be on board?
I have no idea, Your Honor, but I don't want to set this way out. I mean, it's... This is not something new. This has been going on.
What's the time frame for a subpoena? $26 witness check fee, and they come to court? Is that how it works?
Yeah, I don't know how easy it is with a police officer.
I think 2 weeks is the minimum. 2 weeks out, Ms. Clerk, put a court date in there, type it in the chat box, and we need to confirm. Give her a witness check and a subpoena fee, and she's to appear at the hearing. Okay, I did get a police report in one of your exhibits, Mr. Fleeman. It's a little fine print, but is that again to show credibility? And the text messages maybe had something to do with the laxatives?
The text messages were showing that for months prior to her withholding, her problem was that Dad wasn't asking for permission to leave the state. It had nothing to do with any other allegations, and all of a sudden it changed. When she withheld, then there was another allegation of sexual abuse.
Paternal grandparents shall be the supervisors temporarily, Dad, until we clear this. Did they have supervisor guidelines on file before with the court?
I don't recall.
Can you just
I thought it was just an overnight supervision in the previous order last year.
Anytime he has the kid, the grandparents have to be in the house with him. He lives with his parents. The kid stays there overnight.
Right.
Dad, you live with your parents, right?
Yes.
Okay. All right, there's no issue. So if you have your kid, then grandparents are in the house. You have your mother, right? What's her name?
Correct.
What's your first name? Maternal.
Suzanne Allen?
Suzanne? Suzanne?
Yes.
Okay. Shall bathe the child. I don't want you accused. I don't want to have any he said, she said. She's a female, and Grandma will do the bathing. Ms. Clerk, can you put that in the public chat box? And also, she's direct chatting me.
I see it in the chat.
I don't see it. The date?
I see Dad lives. Oh no, not the date. I see the other stuff.
It'll pop up there in a minute. I tell her to put it in the public chat box. There it is. Okay. Let's see. Attorney Fleeman to file supervisor guidelines. So that would be Grandma and Grandpa signing those and file it. JEA to email guidelines to both attorneys. Okay. If you have any additional other records, court will get updated, if they exist, CPS records since we last ordered them. JEA shall email current CPS recs to the attorneys. And I don't know if Metro has a file, but if that's the related police report, we have that exhibit. I can re-review that. But if you have any other additional documents, Mr. Robbins, police reports as well, you're free to file those. But we're going to have a one-on-one talk with Detective Heredia to see if they will proceed. So that will hold us over until September 1st, 10 a.m. Make them the only... It's about a 30-minute slot, Ms. Clark, so make sure you block them out for 30 minutes. Okay?
Your Honor, can you give me some guidance on how to transmit these videos to Mr. Fleeman? You know, I don't have possession of the video because I told Ingrid, you know, I don't want to be in possession of this video that is child and graphic in nature.
Do you use Dropbox or a cloud or Amazon Photos, Google Photos?
Well, Your Honor, I think the problem is that the videos may have child pornography on them, and none of us want it.
Right, that's my concern.
Regardless of whether there's a court order or not, I don't think that any of us want it on our servers, which is where we would keep it.
I don't want to possess it. I
would
want to
prefer
transmit it.
I would prefer that the detective handle that, and we defer to the detective.
I see.
Then have transmission.
If that's your concern, then we'll leave it like that then. Okay. Now, let me defer until we have our next court hearing, because otherwise, if you ask for psychological evaluation, that's going to cost some money. If you ask for a custody evaluation, that's going to cost some money. But I don't know how entrenched these parties are. They're super polarized right now. And listen, sexual abuse allegations, that's nuclear war. If there are absolute, credibility issues and there are competing best interests of the child factors about co-parenting, level of conflict, able to meet the child's needs. I just had a 6-day trial, with Jimerson and, 3 other prior attorneys, but it resulted in a 71-page decision. 71 pages, and a parent lost custody. Okay? So if I do set this thing for a trial, do all that custody evaluation, you will have a new judge for the trial. I will tell you that. But like I said, these are serious allegations. If you cannot make your case, if there's other things going on, credibility, and your conduct and your behavior as a parent, and it is causing harm to the child, your own behavior, you could lose custody. You would be restricted normally to supervised visitation or very minimal visitation, very minimal. And the basis would be to protect the child from any further harm because of a parent's conduct or behavior. I'm not pointing fingers here. I'm addressing it to both sides. So these are very, very serious allegations. And best interest of the child factors, I had 2 competing expert doctors testify on that. It was a full-blown case. Okay, so we had Dr. Bergquist, Dr. Holland, very lengthy decision. Except if it goes to trial, you will have a new judge for the trial because that's how far we're setting out. We'll be back in short time though, so we'll see if we're going to set this thing down for trial. I understand, whether you have the agencies making no reports, they're closed out. I still have to see under Rooney versus Rooney if there's adequate cause to go forward on an evidentiary hearing or maintain the custody decision. Just a heads up, I've had full-blown arguments on that. Make sure you check, Nance versus Ferraro and McMonigal and Castle v. Simmons. A parent can use stuff, anything prior to the court order on a defensively to defend their custodial status. A parent cannot go back and use, the pre-McMonigal stuff to make it as a basis for a change of custody. So it has to be new stuff since the last custodial order. Okay?
It can be shown under best interest to be a pattern, a continuing pattern, an increasing pattern, right? Under Castle and if there's continued...
Nance versus Ferraro, all I'm saying is read the decision closely because it's for defensive purposes or for offensive purposes. So using this evidence to defend your status or to change custody. There's a strong distinction. The Supreme Court said trial court can rely on the underpinnings of the past, the history, and all that to look and see if the parent is using that evidence to defend their status. But new stuff has to be alleged since the last court custodial order to move for any modification of custody. But read the decision carefully in terms of, if this is all going to be trial evidence. If first of all, get back to that Dr. Bello, the psychologist, did Dad knows who she is?
No, Your Honor.
Mom unilaterally picked a psychologist. Was that a CPS's recommendation, or she did this behind Dad's back?
It was behind Dad's back. Originally, she did it shortly before the deposition in the last case. she disclosed that she had taken the child to a psychologist without any notice to dad, and that was that the psychologist at that time had supposedly reported it to CPS. We ended up closing out that case and agreeing to the physical custody timeshare that the court sees in the order. After that, apparently mom has taken the child again. I don't know if it's the same psychiatrist or psychologist or not. But no notice to dad either time.
Mr. Robbins, this psychologist, Dr. Bellows' records, would mom have any issues signing, I'd order her to sign a HIPAA release and get Dr. Bellows' records. And Care for Kids, I think, is the company. Have it sent to the court, and I'll forward it to the attorneys under a confidential gag order. There, okay?
Can we have a deadline on that, Your Honor?
Depends on how.
In terms of requesting it from the Dr. Bellows.
Mom needs to sign a HIPAA release. Would you forward an email to Mr. Robbins? Are you staying on in this case, Mr. Robbins, until you file your withdrawal? Are you retained?
Yeah, I'll be here. I'm unbundled. I'll be here for the September 1st hearing, and then forward from that, we'll see.
Okay, so in the next 24 hours, Attorney Fleeman is going to send you that HIPAA release. Have mom sign it so that they can order the records from Dr. Bello. And if Dr. Bello can send directly to the court, email or PDF, and then we'll hit her forward. We'll forward it to you guys, and we'll get you all the.
I think it makes more sense to put the onus on mom to go to Dr. Bello and get her release, because a lot of these doctors want their specific release signed. If I create something, give it to mom, and then Dr. Bello doesn't accept it, we're going to go in this circle for a while.
It'd be a lot quicker. Police don't trust each other. If dad walks in with his release in a court order, you want to put it in a court order, you can get it that way as well. But the doctor's kind of funny about that. She could send it directly to the courts.
I'll submit a court order.
Yeah, and you want a psych eval versus a full-blown custody eval. I just have some backup. I don't. If I adjudicate those requests, you will have some names at least, and let Mr. Robbins know in case he stipulated to a court-appointed. Yeah, let me put that in there. Attorney Fleeman to have a list of proposed forensic evaluators, and I would have to draw the distinction whether it's a psych eval on mom or a full-blown custody eval, because this goes to their parenting, their communicating, and their behavior. So custody eval will obviously be a lot more expensive, but it's a lot more comprehensive. And then either party, if they want to hire their own expert to challenge the expert's report, it is going to be court appointed, and then the lawyers stipulate to it, so they're court appointed, and then either one then can get their own experts if they want.
How many names, Ron?
Up to you. There's not many on the list. You've got Holland, you've got Bree Mullen. That Jimerson trial I had was Bergquist and Holland. Bergquist was the court appointed, and Holland testified on Bergquist's testimony. So I think there's Bree Mullen, there's Gravely, there's, I don't know who else, Pellini, but I don't know if he's retired. And that's about it. Lenkite retired. There's not that many on the list. They're psychologist level. Is Dr. Collins still doing it? I don't know. You check the court-approved list. Okay. We need a quick order. Any volunteers?
Yeah, I can draft the order.
Thank you.
I'm going to do a separate order for the release of the records, if that's okay.
Oh, yeah, I'll let you handle that with Attorney Robbins. Just email it, and then mom is to sign it and then take a picture of it and then email it back to her attorney, give it to you. Mom can get her own records straight from Dr. Bello. It's a lot faster. Make copies, Mr. Robbins, and send it over, or email it, scan and email it to Mr. Fleeman. You got to hurry and do this because That's the only one thing we need is the Dr. Bello records if you want me to take a look at everything. Okay. Yeah. And we'll leave the child videos over to the detective, so we're not going to deal with the videos. We'll leave it to the detectives for good reason. Thank you. Everything's all there in the chat box. I'll see you guys on September 1st at 10 a.m. Have a good day.
Can we stipulate under EDCR 7.50?
I'm going to put that in the chat box so it's in writing. All right, so Dad, technically you're now under supervision with your parents, and you can't be left alone with the child, and you can't bathe the child. So that order must be followed effective now until
Follow
I...
the order.
All right, thank you. Have a good day.
Thank you.